Okay, great. Hello, everybody. And thank you very much for joining us for what promises to be a really exciting and insightful conversation about the Jamaica Data Protection Act and how this applies to the medical fraternity. I was just giving it some time to allow people to join, but I suspect we can get started with the introductions and the preliminaries while the other participants join. We do have quite a bit to get through today, so we won't necessarily spend too much time on the preamble. My name is Andre Palmer, and I am the Director of Strategic Client Engagements at Symptai Consulting, and I'll be the host of this webinar. The webinar has been appropriately themed, Your Patient's Privacy, Your Priority. And there has been a lot of conversation since maybe 2018, since the passage of the General Data Protection Regulation. And I know we've been ventilating data privacy and data protection for a long time. And since the passage of the Jamaica Data Protection Act in 2020, those conversations have become louder. But with just 1 month to go until full implementation of the Jamaica Data Protection Act, we thought it was an appropriate time to have a very targeted conversation, specifically for medical practitioners, because there have been some conversations in the space about whether or not the Act applies and which section of the Act applies to the medical field and how the Act should be implemented and some considerations. So we're going to be ventilating all of those questions and concerns in this webinar this evening. Just before we get started though, I'd like to quickly tell you a little bit about Symptai Consulting. We are an IT consulting firm based in Jamaica. We have been in operations for 25 years, and we have worked in 26 countries. During that time, we have worked with over 440 clients within the data privacy space, but also in other things such as cybersecurity, anti-money laundering, digital transformation, IT audits, and so on. Won't spend too much time on that because I'm sure we want to get to the meat of the matter. So I'm being joined this evening by an exciting panel. We have Celia Barclay, who is the Jamaica's first information commissioner, and Celia was appointed on December 1, 2021. She has authority over establishing the office's structure and determining its operations. And Celia brings more than 14 years of experience practicing law in the private and public sectors, and 10 years of experience in management and administration roles. Joining Celia is Dr. Karina Davis-Irons. Dr. Davis-Irons is a medical practitioner specializing in anesthesia, pain, and critical care, holding a master's degree in medical law and ethics, complemented by a graduate diploma in law. Additionally, she possesses GDPR officer certification, and she has garnered significant experience in the realm of data protection, particularly in the context of healthcare while working in the Cayman Islands. And joining the two lovely women, I would say the thorn amongst the roses, Andrew, but I'm sure you hear that all the time, is Andrew Nooks. Andrew is the Chief Risk Intelligence Officer at Symptai Consulting and the Director for Data Privacy Services at Symptai. As a cybersecurity and data privacy practitioner, and also a practitioner within the space of information systems, Andrew brings over 30 years of experience to this conversation. Celia is going to be talking about the Jamaica Data Protection Act, just pretending as though you're hearing about it for the first time. So do forgive us if you get a little bit granular. Dr. Davis-Irons is going to be talking about some of the considerations, particularly for medical practitioners. And Andrew is going to be talking about some implementation considerations to help guide how aspects of the Act may be implemented within the medical field. So I will hand over to Commissioner to start us off, just to talk about the Data Protection Act, and then after which Karina is going to be coming on, and then followed by Andrew.
All right. Good evening, everyone. And of course, thank you all for being here. All right. So my role is to just take you through the Act in terms of its applications to you based on your specific area of practice. Now, first and foremost, let me just speak to the implementation date, because I believe most, if not all, persons online would have heard about the post-cabinet press briefing last week and the announcement of Minister Maurice Dixon regarding the phased implementation of the Act. So this is just to point out and to clarify for persons that first and foremost, the Act does come into full effect on December 1. And this is consequent on the 2-year transitional period provided by Section 76 of the Act coming to an end on November 30, 2023. Now, when we speak to phased implementation, what we mean is that while all sections of the Act will be lawfully in effect, we will have the discretion to determine in terms of how those sections are applied as we go forward as a new jurisdiction with this legislation in place and in operation. Now, we want persons to first and foremost understand exactly what the Act means, not just for them, but also in the context of their doing business and dealing with other individuals. So the first thing I'd like to point out is this Act speaks to personal data and its use, and only personal data. So it's not dealing with the data that relates specifically to businesses or business practices outside of where that relates to the processing of personal data for individuals that they provide a good or a service. And it's important to note that it applies not just to those persons that are still alive and being served, but also to those persons that would have passed away anytime within the past 30 years. And when we speak to personal data, we're looking at all the ways in which individuals can be specifically identified as being a particular person, John Brown, Jane Doe. And so whether it's a simple information such as your name and your TRN, or more specific information such as your genetics, your behavior, physical makeup, and even as far as it goes to your political beliefs, religious associations, memberships of any organization, these are all information that can be used to identify you, and this is what is protected by the legislation. And when we look at processing, because that's what the legislation speaks to, ensuring that personal data is protected in a way, processed in a way that is rendering sufficient protection to the persons to whom it relates, we just note here that processing covers just about every activity that you can have concerning the use of data. So everything from where you obtain the data to where it is no longer usable to you and you destroy it is covered under this legislation. And the legislation does require you to take the necessary steps to protect it. Now, we also want persons, as we go through, to be mindful of the different players when it comes to data protection, because you're going to be hearing these terms as we have the discussion about how the Act is specifically relevant to you, as well as steps that you need to take in order to get compliant. So we have the person to whom the personal data relates, which is the data subject, and then each medical practitioner or other person online who may be controlling how that data is processed and for what purposes is considered a data controller. If it is that you practice overseas, but you're processing the data of Jamaicans resident here or providing a service here, then the Act does require you to appoint a data controller representative. And so that will be the person that acts on your behalf in this jurisdiction as it relates to your obligations. A very important individual that is provided is the data protection officer. And I'll slow down a little here because we want persons to appreciate the role of this particular person under the legislation. The data protection officer is going to be that individual that is appointed by a data controller to assist them in ensuring that they are compliant with the Act. So the Data Protection Act imposes all the obligation for ensuring that personal data is protected on the data controller. But recognizing that the data controller may need help, there are some controllers that are required by the Act to appoint a data protection officer. Now, these may include public authorities, persons who process personal data on a large scale, but also in the particular case of this audience, persons who are processing what is considered sensitive personal data would be required to appoint a data protection officer. And the purpose of this officer is to firstly review and observe your data protection practices and to ensure that they are in compliance with the requirements of the Act. This is a person who is going to advise you as to whether there are any particular risk of which you should be mindful. They can make recommendations as to how you can mitigate against those risks. The person will serve as a liaison between you and your data subjects, the individuals whose information you're processing. And of course, they will also liaise with the Office of the Information Commissioner in ensuring that you are complying with the requirements of the Act. And where it is that you have any processing activities that are carried out by somebody external to your organization pursuant to a contract, then that person is regarded as your data processor. So as we go through, just a note in terms of who are the data controllers in this group among us. So you will see here, and I won't go through each one, a list of the acts or categories of persons that within the context of the Data Protection Act would be considered data controllers. So if you are operating, carrying on a practice, whether individually or as part of a group, whether as a public entity or as a private practice, and you're doing it pursuant to any of these legislation or by providing any of the services listed here, then you would count as a data controller for the purpose of this legislation. And so you have to be mindful of what your compliance requirements are. Now, the Act speaks specifically to health records, which most of you would be dealing with on a day-to-day basis. And there is a requirement for these records to be not just protected, but specifically and specially protected because of their very nature. And the definition given for health records, you will see, includes everything from your genetic and biometric data to data that is required just in order to facilitate you in providing care for a patient. And this is regardless of whether you are presently providing the care or this is a past patient, and regardless of the type of condition that you may be treating. Now that you would recognize that you are in fact data controllers under the legislation, you have to ask yourself, what is this Act asking me to do? How will I go about ensuring that I comply with the requirements of this legislation? So I've listed here, and the presentation will be shared to those persons. I do give Symptai permission to disclose the presentation and distribute it to the participants, but you are required as data controllers to firstly appoint your DPO, register with the OIC, and we do start registration effective December 1, 2023 when it comes on board. Sorry, I'm seeing someone saying that they are not seeing the presentation. They're only seeing the presenters. So while I proceed, I'm gonna just ask Andre if you can address that in the background. So controllers, being the medical practitioners and other medical service providers, will be required come December 1 to commence registration with the Office of the Information Commissioner. They will also be required in each year within 90 days of the end of the calendar year to submit what is called a data protection impact assessment. Now, this is there to help you in terms of identifying the risk in your processes, as well as the steps that you need to take in order to mitigate them. And it's also a monitoring tool which will assist us to better know what the activities of data controllers are in order for us to be able to carry out our own mandate as a regulator. But most importantly, the Act provides for 8 data protection standards which set out the mode and manner in which information that is being processed is supposed to be processed to ensure that it is protected and that the rights of the data subjects are secured. Speaking of rights, there is a requirement imposed by the Act on all data controllers to ensure that in carrying out their processes, they give due regard to the risk to the data subject and balance the interest of the data subject against their own. In the event that there is any security breach that affects the data subject or that compromises the information that is held and being processed by the data controller, then there is a requirement for it to be reported to the Office of the Information Commissioner and for affected data subjects to be notified. Now, We won't get into this in too much detail this evening because we do recognize that it is a fairly short session and we anticipate there being quite a bit of discussion as it surrounds the different requirements for controllers. But we have included in the presentation a list of the different standards that the Act prescribes for the processing of personal data. And we want to point out to persons that there is now a requirement under law for data to be processed fairly and lawfully. You have to be very specific in terms of the purposes for which you're processing data. And once a data subject consents to you processing their information for a particular purpose, then you are limited to processing that information for that purpose. There is great concern in the law and an expectation that data controllers will ensure that the nature of the information that they process is adequate, it is relevant to the purpose, that you limit the amount of information that you receive to what is necessary for the purpose, and that you also keep your records up to date and accurate. So you can tell, even from the nature of your industry, how important it will be for you to meet these particular standards, particularly as it relates to accuracy and the up-to-dateness of your records. In addition, there is a requirement in the legislation for you not to keep your personal data that you process for individuals for longer than is necessary. And so persons will now have to look at the purpose for which they receive the data, whether or not that purpose has been served, and the likelihood that the information will be required again. And where it is not, take the necessary steps to dispose of it in appropriate ways, which may include rendering the data unusable by any other person. Now, the other three standards speak to processing the data in accordance with data subjects' rights. And we will look in a short minute at what some of those rights are. But there's also a requirement for there to be what are called appropriate technical and organizational measures to ensure that the processing that you conduct does not put the data at any particular risk. And by this, we mean you don't want anybody to have unauthorized access to the data or to use it in a way that it was not intended. You also don't want to risk that data being lost, damaged, or compromised in any way. And so each person, whether it is you're operating within the public sector or you're operating within the private sector together with others or on your own, now need to look at how are you going to organize your work practices to ensure that when you receive clients, patients' information, it is properly secured and not at the risk of access to persons who should not hold that information. And we also pointed to the requirement, which is known as the 8th standard, that prohibits information, particularly personal data, being transferred outside the jurisdiction to territories where that information might be vulnerable because there are not adequate laws in place in those countries to ensure that the information is as protected there as it is here. Now, a lot of persons might be wondering, is this legislation essentially going to prevent me from doing business? No, it is not. A part of our messaging is just to ensure that persons appreciate that the Data Protection Act is made to allow for the continuity of business, but to ensure that in carrying on your business, that you have due regard to the privacy of the individual. And so one of the things it looks at is in terms of specifically the processing of personal data and particularly sensitive personal data, what conditions need to be met in order for you to proceed. So some of the requirements include for the data subject to have given consent to you processing the information in a particular manner, where there are circumstances where it might be necessary for you to deal with this information for the protection, whether of that particular data subject or of another data subject to protect their vital interest, or if it is that you are processing the personal data in a manner that ensures that it is properly protected and the rights and freedoms of the data subject, including as to their choice and their right of access, are also protected. As it relates to medical professionals, we note that information, personal data, sensitive or regular personal data, is allowed to be processed where it is necessary for medical purposes. And I point out here that medical purposes, again, is specifically defined by the Act. And it does include everything from a treatment of somebody with a view to preventing a condition, to diagnosis, the purposes of research, as well as any steps that you may need to take during the course of caring for a particular client. And so the processing here is whether carried out by a health professional directly or by an individual within the industry who holds the same kind of duty as a health professional would to the person being treated. Now, we mentioned the access rights of the data subjects, and there are additional rights beyond just getting access to information. Again, in the interest of time, we won't necessarily dwell on all the rights individually, but just to point out to the practitioners who are online and certainly other service providers that we have a relatively common practice in Jamaica where, because of the nature of medical information, sometimes there is a reluctance to provide it directly to the client, and a tendency, for example, to share information from doctor to doctor. So one of the considerations that comes up as we look at the rights of the data subject is as it relates to the information that the data subject is entitled to receive. So you must know that under the Act, the data subject does have a right to know what information you process on their behalf, the purpose for which you process that information, and how that information is shared. But most importantly, if the data subject requires it, particularly if there is a cost attached and they have paid the fee to obtain it, they are entitled to receive a copy of their personal data that is held by you. So this may in fact include their medical records if they so desire it. Similarly, in specific circumstances, your clients, your patient may determine that they no longer consent to processing of their personal data for certain uses. And also, they may withdraw consent that has previously been given. Now, we're gonna look a little bit at additional entitlements because this is important. Even though it is not listed as a right of the data subject, this is an opportunity that the data subject has to obtain a remedy where the data subject is aggrieved. And it's one of the reasons that persons should have due regard to the rights of the data subject, because if properly affected, particularly where the individual suffers some damage or distress, then that person does have a right to compensation by controllers. And so this is something that persons have to be mindful of as they carry on their practice, and noting that they must comply with the legislation to avoid this particular implication. Now, non-compliance, as with all legislation, does come with certain penalties. And as the presentation is going to be shared, I just wish to point out, I've not included here all the actions that may constitute an offense under the legislation, but I have sought to put in some of those which are most likely to become effective as it relates to different data controllers, and particularly the persons who are online today. So we can see here where the requirement for registration is of great importance, because once we commence registration, and details will be provided subsequently by the office as to how we propose to phase requirements such as registration, but where it becomes mandatory for a particular controller or group of controllers, then you must know that processing without registration does carry a penalty if you are convicted. Similarly, if you are contravening any of the data protection standards that we mentioned earlier, then that also carries a penalty. And insofar as the Act requires you to report any breach or contravention to our office, as well as to notify data subjects, then it means that where you fail to do so, you would also be creating an offense under the Act, for which there can either be a fine or imprisonment, depending on the severity. And these are prosecuted by the Director of Public Prosecutions. Now, for those individuals that might be a part of an organization, whether it is that you work with a hospital, with a private health facility, any entity that might be registered for providing health services, just to know that there is provision in the Act for any offenses that are committed by that body corporate to still be penalized, and for the individual actors within that entity who might have been a party to the commission of the offense to also be punished together with the body corporate. And those penalties tend to be relatively severe. So the need for compliance with the legislation is fairly high. Now, one of the things we encourage persons to do is to look as they go forward with their business practices at the arrangements that they have in place for dealings with personal data. And so one of the things that you need to do in relation to your health records is look at, is this something that you are dealing with solely by yourself, or is this something that you are engaging external parties to assist you with? And what are the contractual arrangements that you have with these parties, and whether the terms and conditions of those arrangements are in keeping with the Data Protection Act. So it may be that as we develop as a jurisdiction, as the Act comes into force, that we now need to look at our contractual arrangements to see whether and to what extent we may need to amend these to ensure that we maintain our compliance with the requirements of the legislation. Now, I'll just wrap up because I know our other presenters also have a lot to say on the topic, and we do expect that there will be quite a bit of questions, in just pointing out some specific considerations that medical practitioners, personnel, and other persons in the industry ought to have. So first and foremost, as it relates to healthcare providers, the duty to communicate information to your patients have always been there. But within the context of the Data Protection Act, that duty is even more important, because the Data Protection Act recognizes that ownership of personal data rests with the subject. And so they have a right to the information, and you now have a duty to provide it, particularly in situations where that information might be requested in writing. And so provision does have to be made in your business practice as to how you will respond to requests for this information from your patients and other clientele within the industry. Doctor-to-doctor data transfers are always necessary from time to time in the treatment of persons for different reasons. You have to now look at balancing the interest in terms of proceeding with care and in terms of ensuring the protection of the personal data. So, for example, it may be a case where expedience would dictate that the easiest way for you to transmit data from one doctor to another might very well be sending a message via phone or otherwise. However, you now have to look at and consider, is this the most secure method of passing the data? What is the risk to the patient if the method that you use is not sufficiently secure and the information is accessed by another person? So these are considerations individuals have to have as they go about carrying out a medical practice. And of course, we know that as practitioners, it's a little easier for persons that are functioning within, for example, the formal and more complex healthcare system. So hospitals would usually have their own records management systems and their ICT systems in place. For individual practitioners, particularly those persons functioning alone, it might be a little more difficult for you to have a system that is as structured and as organized, but you now have to recognize that this act covers information regardless of how it is stored. So whether you create manual records or electronic records, insofar as you are maintaining the personal data of individuals, and particularly where that data is sensitive, you now need to look at how that data is stored, how that data is to be protected, and ensure that you have all necessary security in place to prevent the data being compromised. So these are some of the general considerations having regard to the provisions of the Act. I'm sure we'll get into a bit more detail as we have further discussions. And of course, I share the contact information because I know we won't necessarily be able to touch on on everything within this session. So persons who wish to reach out to the office can, of course, get in touch with us. Thank you.
Great. Thank you so much, Commissioner. And I do know that it is a very meaty topic. And the issue of the Jamaica Data Protection Act is quite an extensive one. So we can, in fact, go on for hours talking about the essence of what the law says. But we're hoping to get into more of the details when we open up for questions. And I do see some questions coming in the chat. So if you have a question and you don't want to forget it, feel free to type the question in the chat. Once we get to the open discussion segment, we will entertain as many of your questions as possible. Now, as you were talking, Commissioner, it occurred to me that the vast ecosystem of medical practitioners is quite in and of itself presents quite a challenge. We're not just talking about doctors, but we're talking about, receptionists, we're talking about pharmacists, we're talking about cardio practitioners and so many different components. So I will now invite Dr. Karina Davis-Irons to talk a little bit about how the Jamaica Data Protection Act is applicable to the medical practice in its entirety. Dr. Davis-Irons, I relinquish control to you.
Thank you. Good evening, everyone, and thanks for attending this webinar. So there are a few things that I would have started with, but our Information Commissioner has already gone through these definitions, such as the personal data, sensitive personal data, and health record. So I'll just start by pausing at health record. So as she mentioned that health record data /data can range from genetic data to patient registration number, etc., lab results, examination findings. The thing about health record or health data is that the sensitivity of it is quite unique. So the data pertains specifically to individuals' physical and mental well-being. And because of the sheer volume of the data, it makes it the unique sensitivity and the sheer volume, it makes it a unique or prime target rather for breach. So persons who breach healthcare data can get demographics. They can get data where they can get sensitive information such as the person's mental or physical well-being. So it's a prime target, and it's sometimes we as healthcare professionals are not keen on the fact that the information that we handle is a prime target for a breach. So I just wanted to start there. Now, importantly, privacy and confidentiality is intrinsic to our ethical standards in practicing medicine. So this is not new. It's intrinsic in our professional code. It's the foundation of basic medical ethics. So if we look backward at our 4 basic medical ethics principles, you will see that they align very closely with what the law is stipulating or the act is stipulating. So we have autonomy, so the right of the patient, beneficence, we want to do what's in the patient's best interest. We want to do good for our patients. So we don't want to have our patients' data being breached. We don't want to have unauthorized access to our patients' data. There's also non-maleficence, right? So we don't want to do harm for the patient to the patient. So for example, a patient who is a mental health patient, if their information gets into the wrong hands, there can be psychological harm to this patient. So it's already intrinsic in how we practice based on ethical practices. But what is new to us as medical professionals is the ever-evolving introduction of now this critical legal component. So it is not only our ethical obligation, but it has now become a legal obligation. So we now have to ensure that we are acting in accordance with the law. And this is not just specific to our jurisdiction. Over the past few years, data protection acts have been implemented across the world. Recently in the Cayman Islands, in the UK, in Europe, etc. So this is not new. So this is an ever-evolving process that is not affecting, that has an effect on the medical community. So it is very important for us to educate ourselves and be knowledgeable of the legal components. Okay, so as I move forward, so our Information Commissioner had already started to look into the 8 standards. So what I'll do, I'll speak a bit more in terms of a medical sense, like the practicality from a medical perspective with these 8 standards. So all data controllers, and our Information Commissioner already went through the definition of the data controller, the data processor, the data subject, etc. So all data controllers are required to comply with the 8 data protection standards as set out under the Act. Now, with respect to the first standard, fair and lawful processing, again, if we look back on ethical principles, for things that were for medical management, anything we're doing for a patient, we require their consent. It's no different for obtaining their information, storing their information, processing their information, sharing their information. We require their consent. And this is based on ethical practices, and again, now evolving as a legal obligation. So please remember that consent, explicit consent is necessary when we are obtaining this data and how we are processing them. And I guess the Information Commissioner would be able to speak some more in terms of the details on the consent and how that is obtained. But as an overview, which we know from practicing medicine, some of the requirements include the patient must be adequately informed, it must be voluntary, and the patient must have capacity to understand the information that is being provided to them, process it, etc. So even the data acquisition becomes very important. We must be very transparent with our patients. We must ensure that they're not misled about why the data is being collected, how it is being processed, and the purposes for which it is being used. So we need to be very transparent with our patients, get their consent, and that will help with the fairness and lawfulness in how we process it. Now, the second one, obtained only for specified lawful purposes. So excessive data collection can lead to breaches and privacy violations, and in this context, regulatory non-compliance. So when we collect patients' information, always remember, sometimes you may feel as though it would be good to record certain information and have it documented, but it may not be specific to your management of the patient. Be mindful of that. So ensure that what you're collecting is for the purpose of why you need it, so for the management plan. And that will help to minimize the privacy risks associated. Data quality now. So medical facilities should ensure that the data, as our commissioner said before, is relevant, adequate, and necessary for the processing purposes. So this also includes authenticity and accuracy of the data collected. And for us, the accuracy is especially important when information is collected from a third party. So sometimes we get information from a third party when our patients are not able to give us the information. And that's not only patients who lack capacity, like, for example, adults who lack capacity to provide us with the information, but we have to consider our children as well. So we're getting information sometimes from grandma, from auntie, from uncle, from the neighbor, etc. We have to be mindful of the information we get, ensure that it is authentic, ensure that it is accurate, and should there be a change, ensure that the change is made as appropriate when appropriate. So that brings us to the fourth standard. Accurate and up-to-date. Ensure that, remember, medicine, the practice of medicine is quite dynamic. And we have evolution of our patients' information. Again, especially if obtained from a third party. ensure that the information that we have on our patients, not just demographics, but also clinical information, is accurate and current. And then we have the fifth standard, limited retention. Ideally, medical facilities should have policies in place. And that is how this is usually achieved. So policies, it's encouraged to have policies in place, ensuring that data is not retained longer than necessary. And in addition to that, there should be a disposal process. So policies and procedures should be in place in terms of how long you keep the data for. And this may depend on the purpose for which the data is being collected. So for example, information being collected, such as demographics, will be different from information being collected for example, laboratory radiographical purposes. So the time frame will depend on the purpose for which the information was collected. Policies and procedures also sometimes include ways in which you anonymize data or patient's information, how you pseudo-anonymize information, and how you erase information. So all of these would fall under policies and procedures of your institution. And as I speak about anonymization and pseudo-anonymization, this brings us to, and even limited retention in general, we think about research, medical research. We have training institutions where it's mandatory to do research at times and or for other purposes. So we have to think about how that information we get from patients, however it is being collected, how long do we retain the information for the purpose of research? When we're going to dispose of this information, how is it being disposed? So we need to have policies and procedures in place for those purposes. Then we have the sixth standard. So process in accordance with the rights of the data subject. So our information commissioner went through that as well. And again, this is also in keeping with one of our basic ethical principles of autonomy, the rights of our patients, to make decisions. So the law has outlined, the act has outlined a whole section of the rights of data subjects and others. So specifically for our patients, right? Patients will have right to access their information, rectify information that may be inaccurate, false, or given by a third party that needs to be corrected. They have a right to erasure, and a right to restriction who has access to their information. And as you mentioned before, data portability. So patients have a right to get a copy of their information, and we should not restrict them from that. They have that legal right. And again, based on ethical principles, it is their right. And then we have implementing processes. So we should, as healthcare professionals in the entities with which we work, implement processes that allow these patients the ability to exercise these rights. So again, you would have policies outlining how patients will be able to exercise these rights. So what channels exist for these patients to access their data? How will their data be given to them? What will be necessary for them to access this data, and etc. With respect to being able to access their data and having these policies and procedures in place, having a smooth process and clear process will help you as the facility or the institution to enhance trust and satisfaction with your patients, because then when they recognize what they have to go through to get access to their own data, all the channels, proof of identification, etc., then they will have more trust in your institution, how safe their information is with you. So it's kind of twofold. Then we have the next, the seventh standard, protected by appropriate technical and organizational measures. I know one of the things that healthcare professionals may may say, you know, our healthcare records are paper-based. Even if it is paper-based, the appropriate measures must be in place to ensure that patients' information, healthcare records are adequately protected and safeguarded from unauthorized individuals. So we're not just talking about information that is electronic health records. We're also talking about paper-based health records. And one of the common things that I can think about, even as an intern, getting information on patients, scribbling it down on a paper, you know, you scribble down your history, scribble down some laboratory results, etc. Those loose pieces of papers can get into the wrong hands. They may have identifiable information. Sometimes it may even be a bed number, but it can have identifiable information that will lead you back to the patient. So we have to be mindful of those loopholes as well. Leaving dockets, patients' files carelessly, maybe on a desk or by a bedside, and having unauthorized persons have access to it. That being said, we have our curious onlookers many times. So there may be someone who, a politician or even one of our colleagues or somebody's relative that may be admitted to the hospital or has visited the clinic. And then you have individuals who may be just curious, why did this person come, why are they admitted? We have to be mindful of those individuals. So all they need is just to see a free health record lying around and have access to it. But those persons who have electronic health records, we have to be mindful of leaving our screens open, not minimizing the screens and having patients' information being accessible to others. So we have to think about those things. The 8th standard international transfers, which our information commissioner mentioned as well, having specific measures in place for transferring data outside of Jamaica. This is very important. From time to time, we have patients that we are seeking an opinion on. Okay, so we reach out to an international facility or a facility outside of our jurisdiction, and we have to share information with them for them to determine whether or not this is a patient they can assist and how they can assist this patient. We need to ensure that on the receiving end, that they have the necessary safeguards in place to protect our patients' information, our patients' data. And if and when we are transferring those patients, how we physically transfer the information with the patient is also important in terms of safeguarding the information, right? So I'm just going to pause there and just make a note of our unique individuals. I have this slide deliberately because we have some unique patients we care for. So we have our pediatric patients. Remember, when we're caring for pediatric patients, sometimes we obtain information that is not just about the patient we're caring for, but we obtain information for other members of the household. So we have mother's information, we have father's information, we have brother's information. We may know that brother had COVID 2 weeks ago. So we have a lot of other third-party information in our pediatric patients' notes, and we have to be mindful of that. So we're not only now concerned with the pediatric patient's data, but we now have other persons' data in that one record. Our mental health patients, similar situation. And then we have our patients, patients for family planning or sexual health, similar situation where we may have other persons' information, which is quite sensitive information in the primary person's record. And similar, another set of unique individuals are our blood donors or organ donors. These individuals may not be direct patients, but we handle information. So for labs, we have to be very mindful of that as well. So in the interest of time, I'm just going to wrap up here. So in essence, just to run through the standards again, In navigating privacy risk within our medical fraternity, we must be committed both ethically and legally to ensure that our communication with patients remain transparent. We gain consent to receive, process, share their information or data. We limit data collection to essential purposes only, ensure that the data we have is accurate and there are timely updates, ensure that patient data is secured. We have a process in place for storage, disposal, as well as transferring, especially when transferring overseas, and ensure that we always respect the patient's rights, especially as outlined by the Act. And I just also want to make mention of social media. We have to be extremely careful how we share scenarios and on social media, not to have anyone ensure there is consent where it is indicated, and two, to ensure that we do not have any identifiable information being broadcasted on social media. And I'll end there. Thank you.
Thank you. Thank you so much, Doc. The more we talk about this, the more I wish we had more time. We scheduled 90 minutes, and I'm now beginning to think that it clearly is not enough time. But I am really dying to get to the Q&A section. I do see some questions coming in the chat, and I noticed that the commissioner has responded to a couple. I will read one out from Paul Stanley because I think it's a really interesting one. Just as Andrew queues up to tackle the next section. Paul typed in the chat and he said, many doctors work as self-employed persons or contractors and work with an established practice. So the practice maintains the patient records, and the practice is the data controller, and the doctor is the data processor in this scenario. Will the doctor in this case need to register with the Information Commissioner? And what can the doctor in this instance do to be compliant with the Act? That's a question that came in, and I think it's an important one because I feel that a number of persons on this particular call are actually, may actually find themselves in that conversation. So before Andrew jumps in, I would like to invite either the commissioner or Karina just to respond to the question that that Paul asked.
All right. So the initial response is that the registration requirement is imposed on data controllers. The Act does not require data processors to register with the Information Commissioner. And so if it is in the strictest sense that a particular medical practitioner, doctor, or other service provider is strictly speaking simply a data processor acting on behalf of someone else, being the controller, then that person would not need to register. However, what this situation brings to mind is that based on the definitions in the Data Protection Act and how it operates, it is possible for one individual to have multiple capacities under the Act. And so just as each and every medical practitioner, each and every medical service provider is in and of themselves their own data subject and entitled to have their personal data protected, in a similar way, you may have a doctor, a pharmacist, another service provider who is both a processor and a controller with respect to different data subjects or in different circumstances. So we know, for example, that many practitioners, they do operate together with a practice. They carry on work for that established practice, but they may also have their own independent practice that they carry on. So it is very possible for the same doctor, Dr. John Doe, to be a data controller with respect to his own personal practice, even if it is that he has very few clients, but at the same time be a data processor with respect to, for example, the hospital to whom he's aligned or to which he provides service. And so persons have to be mindful of what their obligations are in their different capacities as they go about processing the personal data.
Okay, great. Thank you. Thank you, Commissioner. Paul, I hope that answered your question, and I'm sure that that particular question is applicable to a number of the participants who are listening in. So thank you for the response. Andrew, I'll hand over to you to make your contributions, and then we'll open up for a few more questions.
Yeah, thank you so much, Andre, and thanks, Celia and Karina. Yeah, you have set a great foundation. It's always easy when you're the last presenter because you can just say ditto and just move right into the discussion. But you know, there are a couple of things from my perspective as a consultant that's assisting persons to get to become compliant and to register that I wanted to just you know, mention a bit. Now, when we look at data protection, we look at it. I like to look at it from the perspective of protecting data about individuals so that we can protect the individuals who the data is about. Again, protecting data about individuals so that we can protect the rights of individuals who the data is about. Now, the thing about it, we've been talking about data protection, we've been talking about privacy, we've been talking about all of that, right? It is not about the data. It is about the people who the data is about. And if we focus on that, then we realize that, you know, it's not as scary as it may seem when we talk about getting ready for the Data Protection Act. There's a lot of a fear, and fear usually comes from the unknown. Now, I like to use the analogy that I played volleyball for a very long time in my early years. And when I became a volleyball referee, my game improved tremendously because now I knew the rules of the game and I knew how to apply the rules, right? And this is what we're trying to do here. If you understand what the act is about, as Celia and Karina would have walked you through, then it means that there's no need to fear. You can apply the act to your advantage. It is a positive sum game, all right? So there are several risks associated with processing personal data, right? There's risk as it relates to invasion or intrusion, decisional interference. When we process data, when we aggregate data, or when we use data for a purpose other than for what was collected. Like for instance, you may collect patient's data, but it may very well be a good starting ground for someone else who is selling medical equipment or medical solution or vitamin solution, whatever the case may be. It may be a good list to share with those persons, right? No, that's wrong under the Data Protection Act, because that would be a secondary use and that can cause harm to the individuals who you are sharing the data with. So again, it is about protecting those individuals from harm. I'm not going to dwell too much on it, but the really and truly what we need to comply with is the standards, right? The standards talk about transparency, lawful basis. Karina and Celia went through those in quite a bit of detail. What I want to focus on is how do you do it? How do you comply? One of the first steps towards compliance. Let me move in closer. I hear I'm a bit low in terms of volume. Hope you're hearing me better now. But one of the first steps towards compliance is knowing who you are. After knowing what the act says, what you need to comply with, is to know who you are, what data you have, who you have this data about, what are you doing with the data, how are you processing the data, if you're sharing the data, who are you sharing the data with? So what we ask when we go in is, first and foremost, we want to sensitize your team, we want to sensitize you, we want to sensitize your staff to say, this is what the act is about, this is how it affects you. Similar to what Celia and Karina would have gone through earlier. Then we look at getting to understand your practice in particular, the type of operation that you have. And through that, we would record the actions that's taken on the data. So we'd record the data that you have, the purpose for collecting that data, the reason why you're collecting that data, if that data is being shared with anyone for the purpose of processing, for argument's sake, we want to know that. From that record, and this is a necessary document, we call it, following the GDPR, the record of processing activities. From that record, we'd have taken several other steps. One, we'd look at your process and we'd rationalize your process. So the team here spoke about the lawful basis for processing data. And a lot of persons dwell on consent, if you have the consent of the individual, but our access consent can be withdrawn as easily as it has been given. So that may not be a basis to rely on. There's legitimate interest, there's medical purposes, which is pretty much where this group would fall in terms of processing the data and the class of data that you're processing. From this also, we would know how it is that we derive policies that would be in line with legislation and in line with your practices, so that we can assist you in making your operations consistent with processing data. We want to look at your contracts. You want to examine your contracts to ensure that you have written contracts, especially as it relates to persons who you're charged with certain parts of your operations. I'm talking specifically about processors. Our law in Standard 7 says that you ought to have a written contract when you are asking a third party to process data. So in the context of, does processors need to be registered? No, but the controller has an obligation to ensure that the processor is holding that information in compliance with the Act. And they do that. One of the first instruments to do that is to have a contract. And anybody who touches personal data, appointing a data protection officer, it seems daunting for especially sole practitioners in this space, right? But the verdict is still out on whether or not you can contract services that can assist you in that process. You want to protect data in your care. Now, this is not, Karina has pointed out, and the commissioner has also pointed out that this is not only about your physical record, about your electronic record, it's also your physical record. So that cabinet that you have that may be susceptible to damage, because one of the measures that you have to do is to protect the data from loss, damage, disruption, that may be susceptible to damage through flooding, water damage, or through fire. You now have to evaluate that cabinet to ensure that the cabinet is waterproof, fireproof, and that it can be secured. Not one of those easy locks that you can easily jimmy and get to person's personal data quite easily. And you have to set up access control within your organization. Who can access what? And that may require you to separate certain types of data. The regular data that your receptionist may see may be different than what the nurse may see, and may even be different than what you as the medical doctor in some cases may be privy to. So you now have to look at setting up access control to protect that. A lot of practitioners that are out there, they also use online systems to store data or to maintain their records. And some of these systems, some are better secure than others. Some use simple passwords to get into. Some, once you get the URL, you might be able to access records. You now have to start examining the systems that you have and the controls around protecting that system, because the integrity of data is important. Can you imagine if somebody gets access to a system? They don't have to remove the data. It don't have to be any kind of ransomware or anything. They can simply start modifying the information within a file. And before you know it, you have a wrong diagnosis and somebody being treated with suffer harm as a result of that. In the event of data breaches, you have to log those data breaches. You have to report them, but you also have to maintain a breach register, right? So that you can determine, what breaches occur, and then you can demonstrate the steps that you have taken to contain those breaches in the protection of the data subject, the people who the data is about. I am trying to get as quickly as possible to the end of this because I want to hear your questions, your particular question, your particular pain points. When sharing data with others, you have to determine what's the purpose for sharing. Am I sharing this to get a second opinion? Am I sharing this because the information that I need is outside of my area of expertise? What's the lawful basis for sharing the data? You have to understand the lawful basis, and Section 24 in particular talks about the lawful basis for sharing sensitive personal data, which medical record falls in that. There's a right to transparency and the duty of confidentiality when you're sharing data. So when you're exchanging data between practitioners and between different service providers, you have to ensure that the data is secure. Email is not the most secure way of transmitting data, right? You may have to, put in other measures such as encryption to ensure that the data is getting to who you want to get to, but only them can see and act on that data. We also share data with insurance companies, or may share in the case of legal, any legal challenges, you may have to share data with lawyers. We also have to be mindful of the categories of data subjects that we are sharing data on. If it's data subjects such as children data, then there may be other considerations to take. I mentioned already the method of sharing has to be consistent with what you're trying to protect. If you're protecting sensitive data, then email may not be the best way. And in sharing data, sometimes we're sharing data, or we're storing data in other jurisdictions. The standard 8 section, I think section 31, I think talks about data sharing and data transfer. When you use a cloud-based system, you may very well be transferring data outside of the jurisdiction. You have to ensure that that jurisdiction have adequate controls, or you yourself have controls in place that prevent anyone in that jurisdiction that hosts that data, to protect the data from their access generally. I mean, that's it in a nutshell for me, because I really want to hear your questions and to be able to answer directly what some of the concerns that you have are. So I'll turn back over to you, Andre.
Great, thank you, Andrew. Again, a lot to digest and very little time. We have about 20 minutes, and we want to facilitate some questions. A couple have come directly to me, 2 by WhatsApp, and one that's actually been responded to. One that came was about the data in physical form. Somebody asked a question via WhatsApp about the fact that all the data is kept, or all the personal information is kept in physical form. Does the Data Protection Act applies? And Andrew answered that question, and so too did Karina earlier. Another one that came, and you kind of you touched on it a little bit, Andrew, when you were talking about how to comply, and it was to register with the regulator. A question that came in by WhatsApp says, what happens if I do not register as a data controller by November 1? So, Commissioner, I think this may be a question for you. For participants on this webinar who are data controllers, we have 30 days to go. What happens if data controllers do not register with the Office of the Information Commissioner by December 1?
All right, thank you for that question. So that allows me the opportunity to address in a bit more detail in terms of the phased implementation of the legislation. Now, we are mindful that there are different states of readiness, and we are also aware that perhaps the vast majority of controllers will not be ready as at December 1 to fully comply with the legislation, and particularly to register. And so we have, first of all, the registration system is being designed in such a way to allow persons the opportunity to register over a period of time. So the form is contemplated to be an electronic form. The process is to be facilitated via our website. And what we have looked at is building it out in such a way that persons can commence the registration process and will have a period of 30 days within which to complete the process in terms of adding any additional information before submitting the form. Additionally, as we look about planning how exactly to phase the implementation, we will be more inclined to proceed as at December 1 and onwards with those persons that we regard as being of greater risk, whether in terms of the nature of the information that they process or in terms of the volume of information or the volume of data controllers. And so that plan in terms of phase implementation will be looking at categorizing controllers, not just in relation to industries such as the medical sector, but also as it relates to size and having persons register, as we said, in various groups, depending on those factors. And so we will be issuing the further details about that plan once it is cemented. So persons can look out for those bulletins from the OIC.
Great. Thank you so much, Commissioner. And I kind of want to follow up on that with a question that Simone French typed in the chat, because it's tangential to the response that you gave. So I'll just read what Simone typed, and I can hear some of the frustration in the question, right? So Simone says, while the importance of the data protection is clear, the system seems to require expenditures which small and solo practices cannot sustain. Even government entities will have challenges. And I am told that in some jurisdictions in Europe, some modifications are made for small entities. Is this so? And how does the Jamaica model align with other jurisdictions? And then she goes on to make a comment that data protection officers or employing data protection officers is not necessarily free. So Commissioner, I don't know if you want to extend your response to address that particular question.
All right, so we are mindful of the cost implications for compliance, as Simone rightly pointed out, and I wouldn't even limit it to the appointment of data protection officers. Compliance overall is not free. So the appointment of a DPO is only one requirement. But as you would have noted from Andrew's presentation, there are several steps that persons would have to take in order to get ready to comply with all the requirements of the Act, in particular, not just registration, but also the various standards and the requirements for protection of the personal data. Now, in that regard, there is a significant adjustment that single practitioners as well as entities will have to make in terms of how they operate. So first and foremost, we do encourage persons plan for compliance. Like every other requirement of doing business that involves some amount of expenditure or cost, it is something that you have to plan for over time, that you have to budget for. And in so doing, what you can look at is the different steps required to be taken and how you can take those steps over time. So as we said, we do recognize that there are different states of readiness. Controllers can look at where they are now, and for that purpose, they can engage one of the several privacy consultants to do a preliminary assessment of their data processing activities, point out to them where the gaps are in terms of compliance, and what are the steps that they would need to do to get to the point of full compliance. Create, for example, a roadmap for them. And then once they have that, they can now look at dealing with it in bite-sized pieces. Now, this is not to suggest that persons should remain non-compliant for any long length of time. It is just to recognize that notwithstanding the 2-year transitional period, we do appreciate that there have been challenges for all parties. And so in that regard, we are willing to be mindful of the steps that persons are taking to get ready. The important thing for us, particularly as a regulatory authority, is to be able to see that controllers are indeed taking the Act seriously and have commenced their journey towards compliance. And so persons need to at least place themselves in a position to be able to indicate what have they been doing and what do they continue to do to get to that point where they will be fully compliant with the Act. And certainly as a first step, you should be looking towards preparing for that registration process.
Great. Thank you, Commissioner. I kind of want to change gears a little bit and talk about some of the practices that we've all observed with some of our medical practitioners locally. So one of the common practice locally is to share information about patients with relatives and friends who visit the hospital, for example. So if my grandfather is in the hospital or my neighbor is in the hospital and I go and visit, and I, may in a conversation with a doctor or a nurse inquire about their condition, I have observed that information is shared very liberally. Doctor, perhaps you could talk to us a little bit about how this practice may need to change within the context of the Jamaica Data Protection Act and what non-compliance could mean for perpetrators.
Okay, so it is a common practice, not just in Jamaica, but depending on cultural backgrounds, you may find it in other cultures as well, because of the tight-knit family unit that some cultures tend to have. And it's definitely something that we have to be mindful of, especially with respect to the law. If we're going to be sharing patients' information with family members, we need to have the patient consent, and correct me if I'm wrong, Information Commissioner. You would need the patient's consent to do that. We can't just go ahead and start to share information with third parties without the patient agreeing to this. And also they have, as Andrew had mentioned before, they have a right to withdraw that consent. They have a right to restrict how much information is shared with them. So definitely it is something that it's a practice that we would have to tailor to be in keeping with the law. And it's going to take some time because it is quite cultural that we tend to share information with family members without realizing that we could be breaching the patient's confidentiality and privacy. And then there's another practice that I want to bring forward as well, Andre, and that is a practice where we tend to have open wards. We have open units that are separated by curtains. A lot of information is shared in earshot of other patients, in earshot of other family members, in earshot of personnel who has no business dealing with the individual patient, and we have to be mindful of that. So that's one of the tasks medical professionals working in such environments have faced with respect to being in compliance with data protection and privacy and confidentiality. We discuss sensitive information in earshot of others, and we have to be very, very mindful of that. Even though we're not sharing the information through emails, in writing, we're doing it verbally without recognizing it's unintentional. Most times it is unintentional, but it does happen. And it may not be directly addressed in writing in the law, but we have to be very mindful that this is a way that we might be sharing patients' information or allowing others unauthorized access to patients' sensitive information.
Yeah. If I may jump in, Andre.
Yeah, man, I was going to ask you to weigh in, Andrew, because I wanted you to particularly talk about the issue of consent as well. So in your contribution, I'd love for you to also touch on that, please. Yeah,
there's a flip side of that too, is when you are being asked to provide information within earshot of others. So you go to your doctor's office in an open or the medical lab in an open setting, and you're being asked some real personal questions that you're answering, and other persons are within earshot.
Yes.
I mean that has happened with me several times, and I'm like, I'm refusing to provide information, and people are wondering what's wrong with you. I'm asking you a question, you know.
Right.
So see the flip side. On the point of consent, yes, persons can give consent, but there are situations when persons may be in the hospital and they're non-responsive.
Without capacity, right?
They don't have the capacity to give consent.
Right.
And in those cases, you know, vital interest becomes crucial. So you may have to share that data because you're trying to protect the interests of the particular patient. It is the onus, I would think, would be now on the medical practitioner to ensure that they are speaking with an individual who has that kind of responsibility, a next of kin possibly, you know, or if that record is available, is one to pull on. But you know, vital interest may come into play where consent you may not be able to get consent.
Right. I think we do get some guidance from the Mental Health Act with respect to patients who don't have the capacity to have that conversation with you. I think we do get some guidance from the Mental Health Act with respect to who is the nearest relative, etc., who we should be having that conversation with.
And certainly the Data Protection Act has some comments on that.
On that, as yes, they do make reference to those.
As it relates to the mental health in particular.
Yes.
Yeah, so here's another interesting one, I think, and also just maybe a follow-up to this bit of the conversation. And it is, the question says, would a patient's prescription be considered personally sensitive information?
Absolutely.
Based on how the law defines.
Absolutely.
Yeah.
Absolutely. And just to add to that, the information, the questions in earshot, the pharmacy is another common place where you may find that, do you have any allergies to what's your date of birth, etc., that is asked in earshot of other patients just standing in a line, or other persons just standing in a line. And another aspect, separation apart from other people hearing your information, we have to be mindful in settings like the lab and the pharmacy that we're giving the correct information to the correct persons or the correct patients. We need to ensure that, and we need to have a process in place so the incorrect information end up in the wrong hands. So my intention could be, I am emailing or I am filling this prescription for patient John Brown. However, I have handed to John Brown Mr. Walker's prescription, and on that prescription, on those bottles, have all the information, what medication he's taking, etc., etc. What we need to have things in place to correct those errors. The procedures have to be in place when errors like that take place. So the pharmacy, the lab, giving results, filling prescriptions are areas where we can have errors like that, where it's unintentional again, but it does happen.
Certainly, and I'm kind of glad you mentioned that, because one of the questions I wanted to raise was really around this issue of harm. So ultimately, what we're trying to prevent is harm to data subjects, where the law is there to protect information about whom the information is about, if I got that right, Andrew. So in the event where the information is released and harm is created, and there can be both objective and subjective harm, the data subject can now file for redress. Commissioner, what does that look like? So in terms of compensation to the data subject, what does that look like? And who is at fault? Who is going to be held liable?
All right, so I'm going to answer the last question first in terms of who is held liable. The Act imposes obligations on the data controller And so even where it is that the controller might have utilized a third party in terms of processing any aspect of the personal data, the real responsibility to ensure that that data is properly protected rests with the data controller. And so if there are penalties to be applied, it is the data controller that bears that penalty. Now, as it relates to where a data subject suffers harm, just to point out again for persons, because it was mentioned in the presentation, you are now looking at essentially two remedies. Because even though we have implemented this legislation and the act does provide for some criminal sanctions, the fact is that in terms of the civil remedy that is available to data subjects, that has always existed, in fact, because the right to privacy is not new. This act is providing for specific aspects of that right, and as it relates specifically to personal data. However, where it is that there is trespass to an individual's right to privacy, then those civil recourse that they would have had in terms of carrying an action through the courts in order to receive compensation from the person who has wronged them still obtain. And that is reinforced within the legislation in documenting and clearly expressing that data subjects are entitled to compensation if it is that they suffer damage. And so the issue in that regard is going to come back to the nature of the damage that is suffered, whether it's damage by itself or it includes distress, the facts and circumstances surrounding it. And these are things that the court can take into consideration in determining the extent of compensation that they will award. However, depending on what the transgression of the controller is, whether it's a breach of security, whether it is a contravention of the data protection standards, then insofar as those may amount to a criminal offense, then as we mentioned, there is prosecution for that, and that could result either in imprisonment or in the imposition of a fine. And the fines vary depending on what the offense is. So you do have fines as low as $1 million, and you also have fines going up as high as $10 million under the Act. You can have imprisonment ranging from 6 months up to, I believe, the maximum is 7 years under the Act, depending, again, as I said, what the offense is that has been committed.
Yeah, thank you for sharing. So I think those points certainly denotes the importance of compliance, but also really just taking this act seriously. I have heard some people in some quarters say that, like a lot of legislation in Jamaica, this over time will become a teethless dog. A lot of bark, but no real bite. But I think just looking at the direction that international organizations have gone and other countries, especially in Europe, have gone, we're seeing a very different type of focus around data privacy and a very different type of focus around compliance too, which means no, Jamaica has to fall in line. I do know that time is upon us, but there is this one question that came in from Germany, and I think it is an interesting one. And I'd love to first to be able to provide a response, because I think the answer to this question may also be relevant to a lot of the attendees on this webinar. The question from Jermaine Martin says, can a health facility deny a patient treatment if they refuse to sign a consent form? I don't know who wants to take that one, so I'll just leave that open.
I will open the door to a fuller answer that perhaps Karina may be able to give from one perspective, but just to note that this is a situation where I would say perhaps there is no wrong or right answer in the true sense. While, as Andrew pointed out, consent is only one of several bases on which you can proceed to process personal data. Now, from the data controller's perspective, in essence, this would be a part of their defense, so to speak, in the event that something goes wrong. And I'm not speaking in a medical sense now in terms of contravention of the legislation. It would assist to indicate where the data subject may have consented to a particular type of processing. However, there are many who would say that consent is perhaps the weakest limb for you to hang on, because there are so many other relevant considerations under the Act and in any particular circumstance. So while it would be good to obtain the consent of a patient, I believe that in all reasonableness, you would have to consider other factors such as the situation itself. What is the nature, for example, of the treatment required? What is the condition the person suffers from? How urgent is this required? So, for example, if it is a case where you need to now apply some form of treatment to save a life, are you now going to allow this person to perish merely on the basis of them not providing the consent? And so in that regard, even outside of what the law provides, there are certain ethical considerations, and I mean, Karina can speak to those that may obtain within the medical sector and based on different legislation that guides doctors. From a legal perspective, however, I would say that the medical practitioner would have to be mindful of, one, what is the nature and basis of the refusal, and also what is the nature of the consent that is being requested, because one of the important things about the legislation is how it defines consent. And there are certain criteria that have to be met for you to even say that you have valid consent under the Act. And so if, for example, the patient isn't fully and properly informed, then already there would be questions raised as to the consent that is being requested before you even get to considering the issue of them refusing to provide that consent. So, as I said, several factors have to come into play, and you do want to look at what your legal obligations are from the basis of complying with the requirements for data protection. But I believe above and beyond that, you must consider what your obligations are as a professional and what the requirements may be in terms of your ethical duties.
Before Karina jumps in, Andre, just want to just bring to light, maybe it's just for my own purpose, right? When we talk about consent from a medical perspective, we have to be mindful that it's two areas of consent that we're talking about, right? A consent for a particular action to be taken, as opposed to this context, where it's consent for your data to be processed. Right. So I just wanted to and ensure that what Jermaine is talking about here is that kind of consent, because and maybe Karina, I'll just turn over to you, because maybe that's just for me.
I agree, Andrew. So the moment you form a relationship with a patient, you have a duty of care to that patient. And if at that particular time there are aspects of the care which could include processing their data, the patient refuses a particular aspect of care, then we should not let that refusal of a particular aspect of the care affect another aspect of care. So I can refuse a patient can refuse for their blood pressures to be taken, but it doesn't mean you're not going to carry on with the rest of the management for the patient. And you've established a duty of care for the patient. Another thing too is that we have to remember that when patients refuse consent for whatever reason, may be for data processing or for management, we have to assess their capacity. We have to assess whether or not this patient is in their right mind. Are they making this decision based on someone who understands what is going on? Capacity can be transient. Is this patient intoxicated? Did this patient just have a few drinks? Did this patient suffer a head trauma? So there are a lot of aspects that we have to consider. So as you said, Andrew, consent, there can be many different aspects to consent. And how I would broadly put this is the patient may be refusing one or not consenting to one aspect of their management. And in this case, it would be they're not consenting to having their data be either shared, processed, recorded, whatever the situation is. But as a healthcare professional, we have established a relationship with them. We have a duty of care. If we breach that duty of care, we may impose harm, and then we can be penalized for that as well. As Celia has said, basic ethical principles, if we go back to that, we want to ensure that we are not doing the patient harm, and what we're doing is to the patient's benefit. But at the same time, we're respecting their right not to have their data be processed in a particular way, if any at all.
Okay, great. Thank you so much. I am really beginning to feel as though we need a part 2 for this conversation, because there are some questions around medical insurance. There are some questions around the size of the practice and some of the other considerations. There are some questions around the 5th standard, which is the retention period. There are also some questions around legitimate interest. There are some questions around the fact that the data has to be, personal data has to be protected up to 30 years after the patient has been deceased, or the person has been deceased. There are questions around whether or not even after death you can state what the cause of death is. There are so many questions, and I wish we had more time to ventilate all of them. With your permission, I really would love to invite all 3 of you back for a part 2 to this conversation, because I do think it is an important part of the discussion, and it's, interestingly enough, it's not an area that we've spent a lot of time on, but the more we've spoken about it today, it has really highlighted the importance of a conversation like this. And Simone French in particular has shared some very interesting and insightful concerns and considerations for medical practitioners that we haven't necessarily ventilated. So collectively, it's about looking at how we can actually come up with some solutions for what now becomes a compliance journey. I invite you all to take a look at our website. We do offer training around the Jamaica Data Protection Act. It's a short course that can be done in as little as under 2 hours if you are very diligent and focused. And it gives you a little bit more information about what the Act says. It also talks about the rights of the data subjects, the responsibilities of data controllers, processing standards, and so on. But also more broadly, we can support you with some of the technical implementation components. So we'd love to hear from you. If you have any questions or concerns, please feel free to reach out to us. I would love to thank Celia, Andrew, and Karina for joining us. I know it's late, and I would love to thank all of you for jumping on and for staying and being as engaging as you have been throughout this conversation. As I said, I do think that we would benefit from a second part of this conversation so that we're able to ventilate more of the questions in a bit more detail. But until that time, I want to bid you all a good rest of night. And again, thank you so much for joining us.